The introductions are going to be by our good friend Kurt Wolf. Kurt's a partner at Quinn Emanuel, and you probably know Kurt as the co-host of the Securities podcast, which just had its last episode after 5 incredible years. Kurt, thank you.
Thank you, Bruce. Thank you to everybody for hanging in this afternoon, whether you are watching online at home or in your office, or whether you're with us here in New York. I know we're getting to that part of the afternoon where we're a little sleepy after lunch, so fill up your coffee, please, because we have some fantastic panels coming your way. I have to say, Bill and Gerbir are a tough act to follow, but if anyone can do it, it's this panel right here, who are going to be talking about digital assets and cryptocurrency, key developments in regulation, enforcement, and litigation. Like Bruce, I'm going to try to keep the introduction short, so panelists, please take no offense. I'm going to run through it quickly. Our moderator for this panel is Jennifer Leete. Jen is a partner at Cravath in DC, where she is a member of the Investigations and Regulatory Enforcement Practice. She's a former associate director in the Division of Enforcement at the SEC. We also have Rob Cohen. I'm not going in any particular order here because they didn't sit where I thought they were, so my apologies. Rob's down the middle down there. You all know him. He's a partner at Davis Polk in Washington, D.C. He previously served in the SEC's Division of Enforcement, including as co-chief of the division's Market Abuse Unit, and more recently as the first ever chief of the SEC's Cyber Unit. We also have Matthew Solomon. Matt is a partner at Cleary Gottlieb in Washington, D.C. Matt previously served at the U.S. Department of Justice and the U.S. Securities and Exchange Commission. Most recently, Matt served as the SEC's Chief Litigation Counsel. We have Dr. Yan Chao, Vice President at Cornerstone Research. Yan consults on securities valuation, trading, financial institutions, financial markets, and financial accounting issues. And among her many achievements, Yan in 2023 was named Consulting Magazine's list of women leaders in consulting. We have Charles Riely a little bit farther down the panel there. Charles is a partner at Jenner & Block here in New York. Before entering private practice, Charles spent about a decade at the SEC, where among other roles, he served as Assistant Regional Director for the Division of Enforcement. And last but not least, from the SEC, we have Jorge Tenreiro. Jorge is Chief Litigation Counsel at the SEC. He also served as Acting Chief of the SEC's Crypto Asset and Cyber Unit. He was also, before that, Enforcement Counsel to SEC Chair Gary Gensler. With that, I'll turn it over to you, Jen.
Thanks very much. Thank you all for being here, and thanks to Bruce for having us. He thanked you for hanging in there and for sort of going through the graveyard after lunch shift with us. But with respect to Bill and Gerbir, I would argue that this is the star panel of the day, because I can't remember a time, with the possible exception of the Sarbanes-Oxley period, when an area of what is often sort of boring and obscure securities enforcement, when an area has received such public focus and it has become such a topic of political discussion. So what we hope to do for the next 50 minutes is to bring everyone up to speed on the very active litigation docket. There's been a lot of activity in the last couple of months. Give you a little bit of history on SEC policy making in the crypto space to sort of set the table, and then talk about what we expect to come in the future. So with that, Jorge, let's start with you. There's been an awful lot of activity in the courts in the last few months. Can you give us some of the highlights?
Sure, and I am going to give some non-court highlights as well. And unlike Gerbir, I do still have to give my disclaimer, which I think you all know, and that hasn't changed. But my views are my own, in my capacity as Chief Litigation Counsel. They do not reflect the views of the commissioners or the staff or really anybody else other than me. I mean, we were busy. We've been busy for the last several years. It's certainly been an exciting and interesting time, as you mentioned, Jennifer, for the reasons you outlined. I think the agency put out, or the division put out, some sort of press release about how many cases they did or we did in the first quarter of 25, year 25. And that was true in the crypto space as well. In December, right before what was going to be a potential government shutdown, does everyone remember that one? we announced a settlement with an entity known as Jump Crypto, or Jump Trading, I mean, it's a parent company, where they agreed to pay $123 million to the SEC in connection with the Terraform collapse, which Grabir discussed at some length earlier. So there was that. And essentially, you can read the order, but we allege that, Jump essentially was involved in the scheme to sort of prop up the stablecoin and other allegations. So another large crypto settlement. This month, a couple weeks ago, before the turnover in administration, there was a settlement what I'd like to consider something called crypto adjacent. A crypto firm known as DCG was charged by the commission with a negligence-based fraudulent scheme with respect to the collapse of the Genesis Earn program. I say crypto adjacent because at issue in that particular case was not any token or whatever, which generates typically more interest or maybe more controversy. Those are the settled cases. And yeah, there's been a lot of activity across the courts, as I'm sure you advise your clients. We always talk internally about how, there can be schedules and calendars and people on the Hill do things that whatever. The courts move their dockets, right? The courts have deadlines, the courts issue rulings, and they just kind of keep going. So we saw that since we last spoke to this group, I guess, which was the day after the election. And folks were asking a lot of the same questions you were asking today that we won't have answers for, but we have more court rulings. So to give one example that I think is probably the most prominent is that the district court in New York in the Coinbase SEC enforcement action, I'll talk about the other Coinbase decision in a minute, granted Coinbase a certificate of interlocutory appeal to the Second Circuit. Essentially, I'm going to very generally describe the decision, but essentially the district court said there's enough struggle. I think she maybe purposely didn't want to use the word confusion, but she definitely said there's enough struggle with the district courts on how to apply Howey to digital assets that I'm kicking this up. I'm making it someone else's problem. And of course, she cited the cases that we all know about and are now familiar in our vernacular. If you do crypto work, there's Ripple and there's Terraform and they're in this court and there's me and Coinbase. And so there's enough here that I want someone else to take a look at this. She did that, I believe, really early on in the new year. Coinbase then had 10 days under the statute to seek a actual, essentially the docketing of the case in the Second Circuit. They filed that petition on Friday, January 17th, which meant that the commission's response was due yesterday. The commission yesterday, or maybe on Friday, we got a 2-week extension from the circuit on what position we're going to take as to whether the circuit should take up Coinbase's 1292 interlocutory appeal. I believe yesterday, my dates, I always get the dates wrong, but recently, Senator Loomis, for example, filed a brief in support of Coinbase's 1292B petition saying you should take this question up. We need guidance from the courts. And I'm, again, summarizing, but her brief essentially said, there's been a change in administration, but this issue might persist. There could be another change in administration. The private plaintiffs are going to continue to sue crypto companies. You should take up this case. So sometime in the next 2 weeks, unless we get another extension, the commission's going to have to tell the circuit what its position is on this 1292B. So stay tuned for that. I'm glad that was delayed from yesterday, so I don't have to answer questions about that. Now, other things have happened, right? At the same time, on January 15th, the commission, before there was a change in administration, filed its merits brief in the Ripple litigation, which is on the merits, on a fully developed record, and after summary judgment, filed its opening brief on the merits on January 15th. And, again, summarizing it very generally, but you all are probably familiar, that brief, which perhaps is now, a question, but anyway, that brief said, we think the district court got it wrong on this distinction between programmatic and institutional sales. That's what the commission said on January 15th. On that brief, I'm almost done, I promise. And so I believe Ripple's responsive brief and their opening brief on their cross appeal is due in April. So that's moving along. Those deadlines move along. Last, certainly not least, it's not so much an enforcement case. It's not an enforcement case, but also sometime in the opening days of this calendar year, the Third Circuit in the Coinbase rulemaking petition, sometimes incorrectly referred to as the mandamus case, issued a ruling. So Coinbase in 22, I believe, asked the commission to initiate rulemaking in crypto. At some point, Coinbase mandamused the commission for not responding and went to the Third Circuit. The commission responded with an order that I think was 2 pages long, thereby mooting the mandamus. But then Coinbase went to the Third Circuit again and said, this response is arbitrary and capricious. Should order them to do rulemaking. The Third Circuit did not go that far. The Third Circuit sort of pushed back a little bit on some of Coinbase's arguments that the commission had to engage in rulemaking, that proceeding by enforcement was not proper in this context. But the Third Circuit did send the order back to the commission to further explain its reasons for not engaging in rulemaking. It was a unanimous decision, though the concurring judge expressed some frustration with the commission's approach. I think the panel majority said, again, generally speaking, the commission doesn't have to do rulemaking, they can do enforcement. But the concurrence said, maybe that's right, but I think here you might have a constitutional notice problem, and I'm just sort of putting that out there. So that was that, and what happens after that, of course, is that because it's not a mandamus where the Third Circuit orders the commission to do something, we'll see what's next, right? There's a lot of options available. One is you could just give a long explanation, but there's, of course, other options available to the commission, and I'll stop there because I think the task force is for later in the talk.
Yes, okay. So that's all very interesting, and that's sort of the, I don't know, flagship maybe is the right word, litigation that's happening right now. Meanwhile, there are dozens of cases in the district courts. Maybe that's the right number?
About 30.
Matt, you have, you were involved in the Ripple case and have represented clients in those cases for years. Do you have any observations about themes, legal theories, how those courts are analyzing the space?
Yeah, well, I guess the first thing I'd say is that Jorge and I have agreed about next to nothing over the past 4 or 5 years, but I think one thing we can agree on is it's been very painful, I think, for the crypto industry to have to put up very expensive fights in courtrooms around the country, but a lot has happened because judges have taken on these matters, and the SEC has fought hard, and the defense has fought hard, and new law has been made. And I think historically the SEC hasn't had enough trials, frankly, and has made law too often by resolutions. So it's been difficult to do all these trials, I think, for both sides, but I think, as Jorge said, there's been now a lot written, at least from the judiciary's perspective, on crypto issues. I'll just talk about one briefly, and Jorge alluded to the secondary market transactions of crypto assets. Going back to the Bill Hinman speech in 2018, I don't know if people still remember that. He was the former director of CorpFin, and he gave a speech in 2018 basically declaring that current transactions in ETH are not securities transactions, notwithstanding that ETH raised money in a primary offering. So that was somewhat of a groundbreaking speech by Mr. Hinman. And he also talked about decentralization in that speech. That was one of the main points about it. Because by the time these trades were happening in the secondary market, he said there had been sufficient decentralization so that investment contracts were not being formed in that market. So he didn't talk about any ecosystems in that speech. And the word ecosystem also wasn't present in the 2019 guidance that the SEC put out. But it's been talked a lot about in recent cases, and particularly in secondary market cases. What is an ecosystem for crypto assets? I'm going to try to say, I think, what it is from the SEC standpoint, which is they would say that an issuer creates a constellation of entities, issuer, promoter, programmers, perhaps others, and they work to improve the viability of the blockchain and have new projects on the blockchain, and that results in the price of the digital asset going up. That is the theory, and that's a theory that we saw in Kick a little bit, talked about, but it really became something the SEC relied on fundamentally in the secondary market cases. Why? Because when you have somebody buying a digital asset on the secondary market who doesn't know who they're purchasing that asset from, it's just somebody else who is anonymous, and may not even know about the existence of the original issuer, you have to have a theory to tie together all of those things. And I think we saw in the Coinbase oral argument, we saw in the Binance oral argument back a couple of years ago, I think the SEC, in order to make a common enterprise in the secondary market between purchasers and the original so-called issuers and others, used this ecosystem theory, developed that. There's now been case law developed around it. And the interesting thing, I think, that we're talking about the Coinbase decision, folks will remember in the Coinbase decision, which was a very negative decision for Coinbase, Judge Fela purported to define ecosystem in a footnote. She endorsed the concept of ecosystem, and she used that to help fortify her opinion that these secondary market transactions were in fact securities transactions because everybody was basically in it together. The efforts of folks in the ecosystem resulted in raising the price of the token, and people in the ecosystem were talking about the projects the whole way through, and that is what she used in part to build her theory that Coinbase should have registered as a exchange, broker-dealer, clearinghouse. Interestingly, in the petition that just went up to the Second Circuit, there's been a sort of a bit of a reversal on that. Judge Fela did say she's not running away from that view of ecosystem, but she thinks it is an unsettled area of the law and one that requires appellate review. So whether an ecosystem exists in the context of a secondary market transaction, such that, again, purchasers can be bound together somehow with those original so-called issuers, that's something that's going to be teed up in the Second Circuit, and it's something that's percolating in the remaining secondary market cases out there right now, including cases like Binance, cases like Kraken, and I think the Cumberland case also, and then some of the DeFi cases also touch on this idea. How do you apply Howey in the secondary market? So it's just one interesting sort of thread that wasn't there in the beginning. It got developed through case law and oral argument through the SEC, and now that's poised to be decided by the Second Circuit, assuming that goes forward, and hopefully we'll get some clarity on that. Do I think the next SEC is going to embrace this theory, this ecosystem theory? I do not. Do I think Congress will? I do not. FIT 21 doesn't talk about ecosystem, but it's out there. There's cases litigating, and the private plaintiffs who are still out there, absent some large-scale fix, are going to continue to pursue this ecosystem theory, I think, going forward. So that's why I wanted to put it out there as something that's, I think, a positive thing in that we've got some case law development and unclear how this shakes out in the next year.
Okay, we'll put a pin in a large-scale fix for a moment and talk about another issue that many of us have grappled with in a variety of contexts, and that is extraterritoriality. Morrison. Charles, how has that issue been dealt with in the crypto space, where we're talking about decentralized networks and internet-based companies?
Yeah, so how does Morrison apply to the crypto space? The short answer is it's complicated, of course, but it's also incredibly important because, as Matt alluded to, the crypto companies we represent are fighting two front wars. They not only have been historically dealing with the SEC, but they're defending class actions and other lawsuits. And so this potential limitation, or this actual limitation to the authority of both the SEC and private plaintiffs, is incredibly important. I think many of us remember when the Supreme Court came out with this decision in 2010, it established the baseline principles that will decide this. Number one is, the keystone is there's a presumption against the extraterritorial application of U.S. securities laws. And the principles behind that keystone are that U.S. law is supposed to govern domestically, but not rule the world. And related to that is the principle of international comity. The broader you give the U.S. law's jurisdiction, the more, or the U.S. jurisdictions or U.S. laws affect, the more possibility you will have to run into another regime's rules and regulations. And what the court tried to do in Morrison is lay out black line rules. And they said, for example, for the Exchange Act, for the U.S. security laws to apply, you have to have a transaction on a U.S. domestic exchange or otherwise have domestic conduct or a domestic transaction. Since 2010, in a lot of contexts, outside of the exchange context, that's been really elusive to define exactly what is domestic conduct and what is not. And so courts have struggled with this in the digital asset space. And just to give you an idea of how courts are grappling with this, and also kind of a coming attraction here, We'll talk about a Second Circuit case that was decided and a Fifth Circuit an appeal on its way to the Fifth Circuit. And just to preface this, you may have sensed it already, but I'm not a complete neutral here. Our firm represents the appellant in the Fifth Circuit case I'll talk about. So the first case I'll talk about is from the Second Circuit. In a class action lawsuit, the Second Circuit found that the U.S. security laws applied in a case brought by token purchasers of Binance. And so, this is obviously a negative decision for the industry. But if you look at it, there's a lot of ways to distinguish it. What really animated the court in that case was that they kind of held on, they focused on the plaintiff's allegations that Binance allegedly had no home and no headquarters. And so they said, look, the usual principles of international comedy don't apply, because if you have no headquarters, there's no other jurisdiction for us to defer to. And so then, turning to the specific facts of the transaction, they pointed to both the fact that Binance had servers in the United States and the fact that Binance's terms of service provided that a transaction was a done deal as soon as the U.S. purchaser made the transaction. And so it kind of made the case that, okay, that's the moment that the transaction occurs. And so that was decided in the Second Circuit. Binance obviously disagreed with that and recently had their cert application denied. Turning to the coming attraction, our firm represents Ian Bellina in an appeal to the Fifth Circuit, where this issue will be poised and decided, hopefully decided by the Fifth Circuit. The Fifth Circuit, this case involves a case against Mr. Bellina, who is a well-known influencer and investor, and the SEC alleged that he marketed tokens and without adequately disclosing his compensation. The court below focused on kind of two things that we will disagree with in the appeal. First is that Bellina used social media, and that it said that was enough to make the offer domestic. And second, second pointed out that there was U.S. purchases. And I think kind of both legs of that decision are subject to attack. First, if you're going to apply U.S. jurisdiction anytime that social media is used, that's going to undermine the presumption against extraterritoriality. After all, YouTube has 3 billion users. Clearly, there's more than America that are using that platform. And second of all, the case law is clear in other contexts that having a domestic purchaser doesn't make something a domestic transaction. Domestic purchasers have every right to go into foreign jurisdictions and make transactions. And we think on the facts of this case that the evidence shows that the domestic purchasers purposely availed themselves of making the transaction outside of the United States. So it's going to be really interesting to see how it plays out. And in some ways, the certainty that Morrison tried to create has been elusive. So we'll see if we can get more certainty here.
That's been true for a long time in a variety of contexts, I would say. So we've so far focused on sort of legal issues and generally registration cases, but I'd like to pivot just for a moment and talk about fraud cases. Cornerstone released its report recently that was sort of a review of the 2024 enforcement docket, and it was a good reminder, at least to me, that a strong plurality of the Commission's cases in the crypto space are fraud cases, include fraud theories, and that it also looks like a strong plurality of those cases, I assume generally the fraud cases, are supported by a unanimous Commission, which suggests to me that the fraud cases are not going to go away anytime soon. And those cases, at least in my experience, often rest on factual proof, right, and economic analysis. So Jan, I thought you maybe could share with a group, talk for a few minutes about how traditional economic analysis and litigation support tools apply in the crypto space.
Yeah, thank you, Jennifer, and thank you for referencing the publication we did last week, which certainly has a lot of interesting analysis and statistics and trends. But I'm here to answer the question you just raised, which is what type of economic analysis we have seen in this space for digital assets, be that security enforcement or litigation matters in the past few years. And the broad theme I have to deal with is we have to ask ourselves this question repeatedly. Can some of the commonly used or routinely applied economic principles and analysis and toolbox we have, can those be applied into the sort of this new asset class, digital assets and crypto? And I guess the short answer is not always without significant modification and thoughts put into it. And that, for me, or for us as financial economists by training, can both be a challenge because we oftentimes have to be confronted with really challenging and novel questions, but also can be an opportunity because it's just, from an intellectual perspective, super fascinating, and we get to be very creative. And I'm gonna give maybe like 3 examples in different related area, and have to do with fraud cases as well. The first example deal with sort of a very widely used methodology or tools, and many of you probably have heard of. It's called event study. And that has been commonly used to deal with price impact, materialities, loss causation, and sometimes quantum of damages in security fraud cases and enforcement actions. So the concept of event study is essentially if you assume that asset price has been reflecting all the information concurrently, then you can look at a short time window after, for example, a pertinent disclosure has been released or a corporate event like M&A has happened, how the prices change. And that can give you a sense of the value implication of that disclosure or that event. But the foundational concept, or a very important critical sort of assumption embedded in this analysis, is you have to assume that the market where this asset traded at has to be efficient, right? It means that it has to incorporate information efficiently and rapidly, and at least the past price trend cannot predict future prices. For example, Apple stock. Apple stock return yesterday cannot tell you how the Apple stock price is gonna move today. So that's a term we economists refer to as random walk. So that assumption has been commonly accepted most of the cases for equity and oftentimes fixed income, not without exceptions. I think Jennifer, you and I, we dealt with some situation where there's significant exceptions. But for digital assets, right, that's gonna be much more contested. When you think about Bitcoin and Ethereum, is the market for Bitcoin efficient? Does Bitcoin prices follow random walk? I mean, there has been a lot of debate in this space, and you can't just use event study as if that's sort of equity or bonds. So that's a challenge. A related challenge or question that's also very important is how you think about the fundamental value of digital assets, right? Bitcoin, how do you value Bitcoin or Ethereum? For traditional financial assets, equity, fixed income, you can think about future cash flow, and you do discounted cash flow, which is a golden rule in valuation analysis. But that's not gonna work as well for digital assets. And that can come into play if you think about fraud cases, where you can think about like financial advisors or asset manager have to have some reporting requirement and value their crypto portfolios. And sometimes you can rely on the traded price. Sometimes the traded price is either unavailable or cannot be relied on. So what do? You have to do fundamental value analysis. But if you cannot use discounted cash flow, what do, right? And that's also an unsettled question in academic community. We have seen economists try to value Bitcoin as a currency and think about demand and supply and how to model that factors. So that has gained more support, but it's remained to be a very challenging question. The third example is related to the increasing trend we have seen in recent years, which is sort of increasing concern or focus in potential market abuse or market manipulation. For example, it can have to do with suspected wash trading, which is inflated the trading volume to create the impression that certain token is more popular or has more liquidity. It can have something to do with cross-market manipulation, old-fashioned pump and dump schemes, spoofing, fund running, misappropriation of information or insider trading cases. So for those cases, a lot of traditional tools and conventional analysis can be applicable. And so far we have been working reasonably well. It has been used in some of the cases people mentioned here, such as SEC versus Terraform cases in the past. If you focus mostly on the centralized trading platform, meaning the crypto exchanges, where you have central limit order book, you can do the traditional analysis of the volumes, the prices, the trading patterns, and the liquidity on the order book. However, where that analysis falls short is it doesn't give you the complete picture, because for digital asset, you have to do the on-chain analysis as well in many circumstances, right? So that requires a completely different type of analysis, a different type of forensic analysis where you have to trace the token flows, how that move from wallet addresses to another wallet address, how that move across blockchains, or how the trading happens in decentralized trading platform or liquidity pools, and you have to understand the smart contracts and the trading protocols. So that's just completely different ballgame and different analysis, and often required for us to get a complete picture of the trading. So in short, conventional analysis work in some ways, but really require you to be mindful about the differences in the unique characteristics of the digital assets and also the on-chain analysis for it to be appropriate and valid.
Okay. I think we'll save for another day the question of how some of those analyses would apply to some meme coins that we've seen introduced in the last 10 days or so. And move instead, Rob, you feel like a potted plant? A little, maybe.
I love listening to Matt and Jorge talk.
Yeah, I'm sure you do. So you were sort of there at the beginning. You were unit chief when the commission and the division started grappling with the crypto space. Can you take a few minutes and table set, remind everyone how we got to where we are today?
Sure, and I think it's interesting to think about now as we consider what's going to happen in the next administration. I think everybody agrees it's going to be different, but exactly how is it going to be different? And so the focus at the beginning, and by the beginning I mean late 2017, early 2018, after the Dow report came in mid-2017, the focus was really on two categories of cases. One was fraud, and I think that's continued through the most recent administration, and I'm sure will continue in the next administration. And the other category were, non-fraud core fundraising events that get to the heart of what the 33 Act is meant to address. And by that I mean, in simple terms, somebody had a business idea, they solicited money from other people that they were going to use in the business, and they said what they were going to do with the money. Right? That's the core solicitation of capital that the 33 Act is meant to address. And I think that's what we focused on at the beginning. We then branched out a little bit as sort of an offshoot on the fraud cases to the celebrity promotion cases, which somehow have continued. And then just started to look at the industry professionals who support the capital raising activity, meaning broker-dealers, but not broker-dealers in a trading role, but more broker-dealers in a role of supporting capital raising, and started looking at the trading platforms. And then as Jorge and Matt talked about, as you move into the next administration, focus really shifted to those trading platforms. And instead of going after individual by individual fundraiser, going to the trading platforms, it really facilitated a lot of the market activity. And that's where you run into the very difficult legal and policy issues that Matt and Jorge talked about, which is the principle of the original category of cases was, I'm raising money for a business and I'm telling you what I'm going to do with your money. Well, on secondary trading platforms, it's probably not there, right? Two people are trading with each other. They don't know who each other is. They may or may not be trading with the founder and not know it. They may be trading with somebody else. The buyer and the seller may not even know what the founder is. They may have no idea what the promises were. The promises may be old and stale and not even out there anymore. So, how do you carry over the core principle that we started with, which is if you raise money for a business, you need to give the potential investors information about what you plan to do with their money. How does that carry over to secondary trading platforms? And it's just been a morass of different court decisions, different judges having different perspectives. Now you're starting to see some effort, at the appellate court. What is interesting, and we'll talk a little bit about, what to expect going forward, is, okay, well, how do you transition to the next phase, which will be this administration? I think there's consensus that the approach will be different. The approach will be less focused on enforcement. But A, I don't think enforcement's going to go away. And then B, I also don't think the approach is going to be, this should just be the Wild West. People do whatever you want with no oversight from any government agency. So I think the challenge will be, how does the SEC and other agencies try and tailor their approach that goes back to the core principle of facilitating capital formation and supporting the industry. If you look at the White House executive order that just came out, right, the emphasis is on facilitating the development of the industry, and not just the developers, but the people who want to participate in the industry, people who want to use these platforms. How do you support that while at the same time still providing, some aspect of protection?
Can you elaborate just a little and explain what the executive order was?
Sure. So there were, like 5,000 executive orders issued in the last week and a half? So there had been an executive order under the Biden administration that really sort of stated first principles of the administration's view of the crypto industry, and not surprisingly, was very focused on, you might say protection, you might also say enforcement. And there was some discussion about supporting the industry, but very clearly the focus was on the sort of enforcement side of things. So the executive order that just came out under the current administration revokes that prior executive order, says that it's the policy of the administration to support, the development and use of, cryptocurrency platforms and digital assets. Formed a task force to sort of coordinate the government response on that. There's only so much you can do in practical terms in an executive order, but it really sets the tone for the next 4 years.
Okay. And then bringing it home to the SEC, Jorge, acting chair Ueda made an announcement of a task force at the SEC. Can you describe that and give color as you feel able?
Sure, yeah. So after a flurry of press releases that I was referencing earlier to close out the Gensler years, there's been, if you go on our website right now, there's been 3 press releases issued by the SEC. One, announcing the naming of acting chairman Ueda as the chairman. The last one, where he named some of the senior staff, for enforcement and others. And the only other one is about the task force. So that goes to show, I think, where maybe the priorities are, right? So the task force was announced, I think, it was either that Monday or maybe Tuesday. Yeah, I have it here. So, as the name sort of suggests, I mean, they call it SEC Crypto 2.0, right? So it's I guess the idea is sort of like a resetter. What are we going to do now? And I mean, I don't want to stray too far from the document because it's new.
Understandable.
But it sort of suggests that the SEC is going to take a look. It names some staff, and then it suggests that the SEC is going to take a look at helping draw clear regulatory lines, providing paths to registration, and I guess the part that affects my life the most, deploy enforcement resources judiciously, right? So maybe a rethinking of enforcement. I've heard folks on this panel speculate as to what might that look like. The task force announcement itself doesn't get into any of that. And then I think it's that, Commissioner Peirce talks about how, it's going to take time, patience, and much hard work. So what I'll tell you that like everything else on this statement is true, like that's particularly true, right? This is a interesting, difficult area where a lot of really good minds have been thinking for a long time, and it is going to be, they're working really hard probably right now on these issues, and it's just started. So I think maybe if we meet again in 6 months, we'll have more to say, or I don't know when, but that's sort of the idea there. And at the end, she welcomes comment, they welcome comments and participation. So I certainly encourage all of you fine folk with your ideas, to the extent you have any, to share them. on this Morrison thing, she issued a statement, I think, last week on a Morrison question. Maybe you saw it, it wasn't on crypto. But the SEC is thinking of paying back some victims of a fraud and may pay some victims that bought on the London Stock Exchange. And she issued a call sort of for feedback on these questions. So Commissioner Peirce always solicits feedback from industry participants on these matters. Matt's writing it down. See, so he's going to go send a letter. So I sincerely welcome. I think we welcome these perspectives because it's not. I don't think there's an easy answer to any of these questions. I don't think anyone thinks that. So more is more. More minds thinking behind it will be helpful.
When she tweets that she's in Minneapolis and invites anybody to come talk to her, do people come, and how does that work?
I think sometimes people do. I've always thought that's a little scary, to be honest with you.
Yeah, I agree.
Yeah,
I agree.
People do come. Yeah.
I mean, in my experience, when she solicits input, she's very sincere about it and listens and thinks. So, Rob, as we discern where this is going to go, or discern is maybe the wrong word, try to predict, we do have a guidepost out there, which is a fairly substantive document that statement that Commissioner Peirce made a few years ago proposing a safe harbor. Can you, in case past his prologue, can you remind everyone what that was?
Yeah, absolutely. And I found it really interesting to go back and reread that.
So did I. I recommend it.
Yeah,
Go ahead.
and it's short, easy to read.
Yep.
So picking up on the idea of, that the approach, I think, is unlikely to just be the Wild West. Nobody pay attention to anything, no regulators, do what you want. Commissioner Peirce put out a proposal a couple years ago and then amended it for basically a safe harbor from 33 Act registration issues. And the idea was that, the objective of a lot of the developers is to develop, Matt was talking about an ecosystem or a platform, but something where there will be, a practical use besides just being a medium of an investment. But that to get there, it takes work. And if there's aggressive enforcement from day one, the developers and the people who want to use it are never going to have a chance to get there because it'll get shut down right at the beginning because the use case is hard to prove on day one and it could get shut down as an unregistered securities offering. So the safe harbor basically gave developers a 3-year grace period to develop their project. And to the point of not an absence of regulation, it was sort of streamlined, sort of focused, regulation. So to qualify for the safe harbor, people had to make certain disclosures. They had to have a 3-year goal. It was a 3-year safe harbor. They had to explain they had a 3-year goal. They had to make certain public disclosures, right? Not in a registration statement, but it had to be from a practical perspective, easily available on a website. And the disclosures included things like the source code, how to access the transaction history on the network, what the purpose of the project was, the plan of development, disclosure of prior token sales, summaries about who the relevant people are and if they were related party transactions, and a warning of it being risky. And then there would be required updates if there were any material changes, a semi-annual update, and then an exit report. At the end of 3 years, sort of report where you were. And if you did those things, you were sort of safe from enforcement efforts for conducting an unregistered offering. But the safe harbor didn't apply to Section 17 or the civil liability provisions of the Securities Act, meaning if you commit fraud, then you're not going to benefit from the safe harbor. And that's both from a commission enforcement perspective and from a civil liability perspective. So, whether we're going to see something like that, I have no idea. But when you think about how does a regulator who wants to both protect investors but also facilitate capital formation and give developers an opportunity to build something that one day can be useful, but only if they get a chance to build it. This was one idea Commissioner Peirce had a few years ago.
Yep. Again, I recommend that everyone go back and read it. I thought it was a very thoughtful document when I took a look at it. So that's one possible direction for regulatory change. There are also a lot of calls right now for legislation. I have my doubts about this Congress getting it done, but Charles, do you have any predictions in that
Yeah, so I think a lot of incremental progress can be made without legislation, but I think there's kind of two forces that are going to point the SEC and others in the direction of seeking legislation. First is, I think the Chair Atkins and the other commissioners were quite vocal at the limits of the SEC's power in this space, and they couldn't just rewrite the rules on the fly. That remains true, and so you can do things like not bringing an enforcement case, providing additional guidance without congressional action, but to make real change, there's an argument that you need legislation. And then also what we've seen in the last 10 days is that things like guidance and executive orders can be tertiary in that they can be wiped out at the snap of a finger. So I think that with the crypto industry, with the wind at their back, I would expect that they would seek legislation. And then if you look at both the executive order that was sent out and the formation of the committee, both referenced that the executive order referenced legislative fixes, and the committee referenced that the SEC's committee would provide technical assistance to Congress.
Okay. We'll see what happens there. Again, I have my doubts, but we'll see. In the few minutes we have left, we should remember that the SEC isn't the only game in town. Matt, what's DOJ been up to?
DOJ has been using BSA AML statutes to pretty aggressively go after crypto firms where it believes that crypto is being used to further illicit purposes. I think that's likely going to continue. I think DOJ generally is going to be much less impacted by the change in administration than the SEC. It's a very high standard to bring in criminal cases. Folks know proof beyond a reasonable doubt. There's no sort of fraud light. There's no negligent fraud. There's no reckless fraud. It's intentional fraud all the way, and it's got to have victims, and it's got to be compelling enough for a jury to, again, convict somebody proof beyond a reasonable doubt. So I don't think there's going to be a lot of changes there. I think BSA AML will remain a priority. We just saw the KuCoin settlement come out a couple of days ago, unlicensed money transmitter business, and a couple of executives. KuCoin took a guilty plea. The execs took a DPA, I think, and the Bittrex case just resolved also, a $100 million penalty there. These could have kicked over, so one thinks that the people settling believe that they would kick over. So I do expect that to continue. Same with sanctions, although maybe a priority on different countries. And the one point I'll make about Morrison is, that's something DOJ is going to have to think hard about because they're going to be resource constrained. Are they going to bring cases that are sprawling international cases where they're going to have to use MLATs to go get, documentary evidence and testimony in New Zealand? I don't know. So some of that may have to be on the cutting room floor because they're expensive to investigate, they're hard to investigate, and DOJ is not going to be able to do everything. But they're not going to target crypto, obviously, but I think crypto firms are going to be treated just like everybody else, and they're going to continue on with their BSA AML program as they've been doing so far.
And then finally, Charles, there's some regulatory risk from other agencies as well.
Yeah, I think the kind of good news, bad news for the crypto industry is that it's become more mainstream. And so as a result, regulators' expectations are increasing. And so we talk about AML and sanctions, and when we counsel clients, we almost treat that as the third rail. And it's one thing to have unregistered securities, it's another thing to have sanctions and AML going through your pipes. There's a lot of risk there. And the kind of two buckets that we put it into is first, if you're subject to the technical requirements of the BSA and you're not doing it, that's an easy case for the government. So that's a very high risk area. And then the second area is this is an area where the government has a pretty good understanding of what the transactions are and where they're going, both from the SARs of other financial institutions and from their own analysis of the chain. And so it's the sort of area where it makes sense to have an AML program and to put resources into doing a very thorough risk assessment.
Okay, 40 seconds left. Any final thoughts?
I'll say look to the states. We've talked a lot about changes in the federal government, but of course the states have tremendous regulatory authority, and some state attorney generals, including in New York, have been fairly active in the crypto space. And in the past we've seen when there's a perception that the federal regulators are taking a different approach, you may see an increase in activity at the states.
Okay. Thank you all very much. As I keep hearing in Washington, buckle up. It's going to be interesting.
Thank you.